But before we go further, one may ask, what is probation? Who is eligible for probation? How is it granted? Or the better question is, how does it benefit a grantee? Stay tuned and join us as we uncover the answers to these questions. This is Probation in a Nutshell. The Probation Law of 1976 was signed into law by then-President Ferdinand E. Marcos on July 24, 1976, which took effect on January 3, 1978, and which then underwent several amendments significantly by Republic Act 10707 in 2015. Probation is a disposition under which a defendant or probationer, after conviction and sentence, is released subject to conditions imposed by the court and the supervision of a probation officer. It is aimed to promote correction and rehabilitation of an offender, provide opportunity for the reformation of a penitent offender, prevent further commission of offenses, decongest our jails, and save government funds. It provides a win-win situation for both the offender and the government. How is probation granted? Probation is not automatically granted though. A defendant must first be convicted and sentenced for a probationable penalty of not more than 6 years or a fine. Within the period for perfecting an appeal, the said defendant must file an application for probation with the trial court. Generally, appeal and probation are mutually exclusive, which means that the filing of the application for probation is a waiver of the right to appeal. While an appeal presupposes that a convict disagrees with the finding of his guilt, probation admits his guilt and implies remorse on his part. But there is an exception. That is, when a judgment of conviction imposing a non-probationable penalty is appealed or reviewed, and such judgment is modified through the imposition of a probationable penalty. The defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. It is worthy to note, however, that the benefit of probation shall be lost if a review of the modified decision which already imposes a probationable penalty is sought. What are the criteria of placing an offender on probation? Upon receipt of the application, the trial court suspend the execution of judgment. The trial court may either grant or deny the said application upon considering all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. The trial court shall deny the application if it will find that the offender is in need of correctional treatment. There is undue risk during the period of probation. The offender will commit another crime or probation will depreciate the seriousness of the offense committed. An order granting or denying probation shall not be appealable. When is probation order effective? The probation order shall take effect upon its issuance. What are the conditions of probation and consequences of its violations? When granted, the probationer is bound to carefully observe the conditions stipulated in the grant. Among the mandatory conditions are to report to the designated probation officer within 72 hours after receipt of the order, and to report periodically to the officer at least once a month or sooner as the latter may deem necessary. At any time, while the probationer is on probation, the court may issue a warrant for the arrest of a probationer for any serious violation of the conditions of probation, or upon his commission of another offense. He shall serve the penalty imposed for the offense under which he was placed on probation.
How long may a convict be placed on probation? If the convict is sentenced to a term of imprisonment of not more than 1 year, the period of probation shall not exceed 2 years. In all other cases, if he is sentenced to more than 1 year, said period shall not exceed 6 years. When the sentence imposes a fine only and the offender is made to serve subsidiary imprisonment, the period of probation shall be twice the total number of days of subsidiary imprisonment. When and how is probation terminated? What are its effects? Section 16 of the Probation Law provides, after the period of probation and upon consideration of the report and the recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions of his probation, and thereupon the term is deemed terminated. The final discharge of the probationer shall operate to restore to him all civil rights lost or suspended as a result of the conviction, and to totally extinguish his criminal liability as to the offense for which probation was granted. Section 9 of PD 968 as amended states that the benefits of probation shall not extend to those who are sentenced to serve a maximum term of imprisonment of more than 6 years, convicted of any crime against the national security, who have been previously convicted by final judgment of an offense punished by imprisonment of more than 6 months and 1 day, and or a fine of more than 1,000 pesos, who have been once on probation under the provisions of this decree, and who are already serving sentence at the time the substantive provisions of this decree became applicable pursuant to Section 33 hereof. Now, assuming that the accused were convicted and sentenced of the crime as charged, can they possibly benefit from the probation law? The answer is in the negative. Section 9 of the Probation Law as amended states that the benefits of probation shall not extend, among others, to those who are sentenced to serve a maximum term of imprisonment of more than 6 years, and those who were convicted of any crime against the national security. Further, under the anti-terror law, any person who are found to be guilty of any acts of terrorism or any among the illegal acts enumerated therein shall be meted out the penalty of life imprisonment, aside from the additional penalties accorded to the respective illegal acts committed under the anti-terror law. In our scenario, no matter the participation or citizenship of A, B, C, and D who were convicted under the anti-terror law, they shall suffer the uniform penalty of life imprisonment aside from the additional penalties accorded to the specific legal acts they committed under the anti-terror law. The punishment of life imprisonment precludes them from benefiting from the probation law, which disqualified, among others, offenders who were convicted to serve a maximum term of imprisonment of more than 6 years. Furthermore, the acts committed by A, B, C, and D are a crime against the national security or public peace, which clearly fall under paragraph B of Section 9 of the Probation Law. Hence, A, B, C, and D are not eligible for probation.